Hello and welcome back to this channel. So, I'm Advocate ANURADHA, and today we will be talking about sections 168, 69, 170, and 171 of CrPc in this video. So, what does section 168 talks about? Procedure after completion of investigation. Now, all these sections cover this topic. So, on the completion of investigation, the procedure prior to this particular topic we have already discussed in other videos. So today we will be talking about procedure after completion of investigation. On the completion of investigation, जैसे ही investigation complete होगा तब उसके बाद क्या procedure अपनाया जाएगा? The police is required to follow certain procedure as laid down in sections 169 to section 173. Submission of the police report is the end result of such investigation. जो भी इन्वेस्टिगेशन होगी उसका एंड रिजल्ट क्या होगा? पुलिस रिपोर्ट सबमिट करी जाएगी बाय द पुलिस. अंडर सेक्शन 172 every police officer is required to maintain a case diary. We will be talking about case diary as well. So after the investigation is completed, there are two courses, there are two ways open to the police officer making the investigation. जो भी पुलिस ऑफिसर ने इन्वेस्टिगेशन की है उसके पास दो रास्ते होंगे. पहला, रिलीज ऑफ एक्यूज्ड व्हेन एविडेंस इज डेफिशिएंट. अगर एविडेंस पूरा नहीं मिला है तो एक्यूज्ड को रिलीज कर दिया जाएगा. If upon investigation it appears to the police officer that there is no sufficient evidence or reasonable ground of suspicion, कि कोई ग्राउंड नहीं बनता उसके पास सस्पिशन करने का उस एक्यूज पे, या फिर अपने पास सफिशिएंट एविडेंस नहीं मिला है टू जस्टिफाई द फॉरवर्डिंग ऑफ द एक्यूज टू द मजिस्ट्रेट, देन सच ऑफिसर शैल, इफ सच पर्सन इज इन कस्टडी, अगर वो एक्यूज पुलिस की कस्टडी में है तो पुलिस ऑफिसर उसे रिलीज कर देगा अपॉन एग्जीक्यूटिंग अ बॉन्ड टू अपीयर इफ एंड व्हेन सो रिक्वायर्ड. अगर भविष्य में कभी उसकी जरूरत पड़ी तो एक्यूज अपीयर होगा. इस बात को ध्यान में रखते हुए अ बॉन्ड शैल बी एग्जीक्यूटेड. Second option, the second option available to the investigating officer. Second option is cases to be sent to magistrate when evidence is sufficient. अगर evidence sufficient है तो उस केस को मजिस्ट्रेट के पास भेज दिया जाएगा. और पहला रास्ता क्या था कि अगर एविडेंस सफिशिएंट नहीं है तो एक्यूज्ड को बॉन्ड एग्जीक्यूट करने के बाद रिलीज कर दिया जाएगा. सो नाउ लेट्स टॉक अबाउट द सेकंड वे, केसेस टू बी सेंट टू मजिस्ट्रेट व्हेन एविडेंस इज सफिशिएंट. If upon investigation it appears to the SHO that there is sufficient evidence or reasonable ground of suspicion exists upon the accused so as to justify the forwarding of the accused to the magistrate. अगर मजिस्ट्रेट के सामने accused का ले जाया जाना justify किया जा सकता है through the evidence, sufficient evidence, then what? Such officer shall forward the accused to the magistrate. तो उसको मजिस्ट्रेट के सामने पेश किया जाएगा. If the offense is bailable, जो भी offense commit किया गया है by the accused, if that particular offense is bailable and the accused is able to give security, और accused security भी देने के लायक है, then shall take security from the accused from him for his appearance before such magistrate. तो उससे वो security ले ली जाएगी for his appearance before such magistrate. This is as per section 170 clause 1. Now let's talk about section 168. This was the gist of the topic that I was about to teach you today. So now let's start with section 168, that is report of investigation by subordinate police officers. Section 168 lays down that when any subordinate police officer has made any investigation under this chapter, he shall report such result of such investigation to the officer in charge of the police station. जो भी सबऑर्डिनेट पुलिस ऑफिसर ने इन्वेस्टिगेशन की होगी वो उसकी एक रिपोर्ट बनाएगा और उस रिपोर्ट को ऑफिसर इंचार्ज के सामने पेश करेगा. Now 169 talks about the release of accused when evidence is deficient. The first way that we've already talked about. 169 states that the accused will be released. Accused को release कर दिया जाएगा अगर sufficient evidence नहीं मिला in the investigation. So 169 lays down that upon investigation under this chapter, it appears to the officer in charge of the police station that there is no sufficient evidence or reasonable ground of suspicion कि उसको मजिस्ट्रेट के सामने ले जाया जाए, then that officer in charge of the police station shall release the accused. He must release that accused such person from custody ऑन हिज एग्जीक्यूटिंग अ बॉन्ड. एक बॉन्ड एग्जीक्यूट करवाए जाने के बाद उसे रिलीज कर दिया जाएगा विद और विदाउट श्योरिटीज एज द ऑफिसर में डायरेक्ट टू अपीयर बिफोर अ मजिस्ट्रेट empowered to take cognizance of the offense committed by the accused. Now, a report of the police officer under section 169 is to be distinguished from the report which officer in charge of the police station submits under section 170 or 173 that we'll be talking about later. लेकिन अभी बता देती हूँ कि 169 में जो रिपोर्ट सबमिट करी जाएगी वो रिपोर्ट जो 170 और 173 में सबमिट की जाती है उससे अलग है. The magistrate may accept the final report submitted by the police if the magistrate disagrees. अगर magistrate disagree करता है by the report submitted by the police officer, then he may take suitable action as in the court, but he cannot impinge on the jurisdiction of the police by compelling him to change the opinion. वो उसको police officer को force नहीं कर सकते कि आप अपना opinion change करिए. Now, section 170 section talks about the cases that are to be sent to the magistrate when evidence is sufficient. This is the second way that I've already talked about. Section 170 is the counterpart of the section 169. This the only section under which a police officer can take a recognizance. Police officer can take recognizance from the accused for his appearance before magistrate. A mere admission of guilt और confession by the accused. अगर accused अपनी guilt को accept कर लेता है by the accused during the investigation of the offense does not necessarily amount to sufficient evidence under this section. अगर accused accept कर लेता है कि मैंने offense commit किया है, then that confession, that admission of guilt is not sufficient evidence under this section as per this section. So the officer in charge of this police station shall send to the magistrate any weapon or the other article which it may be necessary to be produced before him. अगर investigation के दौरान कोई भी weapon मिला है, कोई भी हथियार मिला है या कोई भी article मिला है, then that particular article or weapon shall be produced before the magistrate. It is necessary for that officer in charge and shall require the complainant. अगर कोई complainant है इस case में, then that complainant and the witnesses to execute a bond to appear before magistrate as thereby directed and prosecute or give evidence as the case may be. अगर कोई witness है, कोई complainant है, तो उनसे भी bond execute करवाया जाएगा in the matter of charge against the accused. This is section 170 clause 2. Now 171, section 171 talks about the complainant and witnesses not to be required to accompany police officer. This is section 171. अब section 171 क्या कहता है? 171 lays down that a complainant, कोई भी complainant या कोई witness on his way to court is not required to accompany a police officer. ऐसा जरूरी नहीं है कि वो police officer के साथ ही आएंगे जब भी वो court में आएंगे. Nor is he to be subjected to unnecessary restraint or inconvenience. ना ही उन्हें unnecessarily रोका जाएगा या रोक के रखा जाएगा to cause inconvenience, or to be required to give any security for his appearance other than his own bond. अपनी कोई security भी देना जरूरी नहीं है, बस वो bond दे वही काफी है. I'm talking about complainant and witnesses here. However, if such a person refuses to attend or execute a bond, अगर वो person bond execute करने से मना कर देता है या appear होने से मना कर देता है, as directed in section 170, the officer in charge may forward him in custody until he executes such bond. उसको custody में लिया जा सकता है जब तक वो bond sign करने के लिए, bond execute करने के लिए ready ना हो जाए, or until the hearing of the case is completed. अगर वो bond execute करके ही नहीं दे रहा है तो उसे detain करके रखा जा सकता है till the hearing of the case is completed. This is proviso to section 171. Now, if a police officer detains any witness against his will, किसी भी witness को अगर पुलिस ऑफिसर उसकी will के against detain करके रखता है, then his act will be illegal, for which he may be liable for punishment. उस पुलिस ऑफिसर को punishment भी दी जा सकती है अगर वो किसी भी witness को witness की will के against detain करके रखे. Any statement obtained from a witness by subjecting him to restraint cannot be regarded as voluntary. This was held in the case of Bajrangi Lal versus Emperor. Now, this is all about section 169, 168, 170 and 171. This is the procedure that is to be adopted after the completion of investigation. Now in the next video, we will be talking about case diary, that is section 172. So please, if you have any questions or any query, you can leave it in the comment box. Please do like and subscribe. Thank you.